Institute of Forensic Science on the thought-provoking theme of law, language, and forensic science, a synergistic approach to justice. This national level academic forum brings together a vibrant mix of legal scholars, forensic scientists, academicians, and practitioners, and research students all across India, all united by a common purpose to explore how law, language, and forensic can coalesce to strengthen our justice system. Let us now begin by extending a warm welcome to our esteemed dignitaries, keynote speakers who have graciously accepted our invitation to be a part of this historic conference. I now invite everyone to join us for Saraswati Vandana and lighting of lamp, a traditional mark of enlightenment and beginning of an intellectual journey.
असतो मा सद्गमय तमसो मा ज्योतिर्गमय मृत्युर्मामृतं गमय ॐ शान्ति शान्ति शान्तिः या कुन्देन्दुतुषारहारधवला या शुभ्रवस्त्रावृता या वीणावरदण्डमण्डितकरा या श्वेतपद्मासना या ब्रह्माच्युतशङ्करप्रभृतिभिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा।
Justice today is not confined to courtrooms and legal texts alone. It demands the joint contribution of disciplines. The conference themes underlines the importance of interdisciplinary integration, where law defines, language interprets, and forensic science evidences. As a gesture of warmth and respect, I now request our director, Sir Dr. Taraknath Prasad, Sir, of Sri Vaishnav Institute of Law for a floral welcome of our esteemed chief guest, Dr. G.S. Bajpai, Sir, Vice Chancellor, National Law University, Delhi. May this token of appreciation symbolize our gratitude and the blooming of academic collaboration. To formally open this ceremony, I now request Dr. Taraknath Prasad Sir, Director, Sri Vaishnav Institute of Law, to deliver the welcome address and share the vision behind NYAYARTH 2025. And I also humbly request Sir to elaborate further on the academic objectives, the conference structure, and brief us on the sessions planned. Sir, we are truly grateful for your constant support, invaluable guidance, and hands-on involvement in making this event possible. Over to you, sir.
Thank you, ma'am. Honorable Chief Guest of the day, Professor Dr. G.S. Bajpai, Vice Chancellor, National Law University, Delhi, heads of Sri Vaishnav Vidyapit Vishwavidyalayas, institutions, all coordinators, and dear participants. A very good morning to all of you. Today, the NYAYARTH 2025, we are having conference in this multi-dimensional approach towards reaching to the end of the justice. The justice cannot stand alone various factors linked to the delivery system has to be understood in its parallels. NYAYARTH literally means the pursuit of justice within the framework of righteous conduct and earning wealth through ethical means. Here I would like to mention that ethical and unethical means is having very close relation. Um, the earnings is earning only. The wealth, be it crores of rupees found in a house of minister or a poor person is struggling for simple penny. The earning, the money doesn't have any its identification whether the money is coming from temple or from a wine shop. Here in NYAYARTH will literally uh, try to connect the role of law, language, forensic science, its evidence part, etc. and etc. The language role, forensic science role, and law, all these three are truly and very closely connected to reach the end of justice. Here, I would like to quote in 15th century, Sant Kabir Das has stated that मैं कहत आखन की देखी, तू कहत कागज की लेखी, मैं कहत उलझावत रे, सुलझावत रे, और तू कहत उलझावत रे. I don't know in 15th century how far availability of papers were there, but the Lekhi and Dekhi, if we compare from the previous situations in 15th century till date, we have lot many differences and available resources like paper and so many gadgets available with us. So this Lekhi and Dekhi both are truly connected with our final justice system. It is said that there is always golden thread around the accused, meaning thereby a person is always considered to be innocent till the guilt is proved beyond reasonable doubt. Here, again, the innocence need not to be proved, but in certain exceptional cases, yes, in present scenario, the innocence also needs to be proved. Only guilt is to be proved. Now, if the prosecution is able to establish 99% evidence against the accused person, the defense has got only one role to create a doubt in the mind of judges that somewhere the accused person might be innocent, so that person has the case to his hand. So altogether, if we find the role of evidence, the role of language, the established legal system will take us to the judgment. If I go back to the novel Chandrakanta, where the female artist Jwala stated, saying that Pandit ji, mera katil hai, and she expired. She could not write the complete sentence. Here, if we minutely see what is the role of language, what she wanted to convey, what is dying declaration under Indian Evidence Act 32(1) and Sakshya Adhiniyam 26(1). Pandit ji, mera katil hai. If she could have wrote mera katil hai so and so, the meaning would have been different. Here, Pandit ji was favoring to her, trying to help her from all odd situations, but she wrote while lying. Means he wanted to convey, look, Pandit ji, mera katil is someone, but the meaning came otherwise. This is how the language plays the role to reach the end of justice. Now, all the system, legal procedure, established laws are again depending on evidence. So without evidence, it cannot go. So if I again refer back that Sant Kabir Das, मैं कहत आखन की देखी तू कहत कागज की लेखी, 15वीं शताब्दी में कागज था नहीं था, आज के जमाने में कितने कागज हैं, कितने एविडेंस रिकॉर्डेड होते हैं, तो डिफरेंस तो है। और इन्हीं डिफरेंस को समझने के लिए आज इस कॉन्फ्रेंस में around 143 papers has been submitted. We have session plenary and two concurrent session. In plenary session, Professor Tiwari is there, and in two concurrent session, our speakers, chairs, and co-chairs are from international and national platforms. So altogether, I am very much sure that all participants will deliver their best to understand the legal and judicial system in our country, which we have. Um, at this position, I am fortunate enough to welcome our chief guest of the day, Professor Dr. G.S. Bajpai, sir, Vice Chancellor, National Law University, Delhi, to bless us, bless this conference, and sir's wisdom will definitely help all of us. Welcome you, sir, once again. Welcome, sir.
Thank you, sir, for beautifully capturing the spirit of this conference. Now we have come to a very special moment of the event, the official release of the conference souvenir NYAYARTH 2025. This souvenir is not just a collection of words and pages, but a reflection of our collective vision, scholarly contributions, and the spirit of legal inquiry that this conference embodies. Now, I request the coordinator of the National Conference NYAYARTH, Professor Ashwathi Chandran Nair ma'am, to introduce our esteemed chief guest, Dr. G.S. Bajpai sir, Vice Chancellor, National Law University, Delhi, who has graciously joined us to inspire and guide with his invaluable freedom, with his invaluable wisdom and insights. Over to you, ma'am.
A very good morning to all. I am Ashwathi Chandran Nair. It is my privilege to introduce a distinguished personality whose contributions to the field of law and justice are truly inspiring. I now have the honor of reading the profile of Dr. G.S. Bajpai, the esteemed Vice Chancellor of National Law University, Delhi. He is equipped with more than 30 years of professional experience as an author, researcher, teacher, and administrator. He has previously served as the Vice Chancellor at Rajiv Gandhi National University of Law, Punjab, and Registrar at National Law University, Delhi. He served as the convener of the Committee for Reforms in the Criminal Laws set up by the Ministry of Home Affairs, Government of India, tasked with spearheading historic reforms in criminal laws in India. The Ministry of Consumer Affairs, Government of India, has nominated Professor G.S. Bajpai as a member of the committee for conferring statutory status to the right to repair under the statutory framework of the Consumer Protection Act 2019. Professor Bajpai has authored 22 books, monographs, more than 60 papers, over 100 op-eds in leading dailies like Indian Express, The Hindu, and The Tribune, and 13 project reports. Professor Bajpai has held many prestigious international assignments for advanced criminal law and criminal justice research. Professor Bajpai also serves as the Vice President of Victim Support Asia and the President of the Indian Society of Victimology. He is the first Indian to be elected as the Secretary General of World Society of Victimology and held the office of Secretary General at World Society of Victimology from 2018 to 2023. Professor Bajpai is credited with designing and pioneering the expression critical criminal law in India, which is now a LLM course in many universities. Besides, he is also credited to have conceptualized the novel paradigms of victim justice, victim jurisprudence, and wrongful prosecution in the Indian context. At the instance of the Honorable High Court of India of Delhi, Professor G.S. Bajpai was appointed as amicus curiae in various cases. His areas of interest include victim justice, critical criminal law, criminal procedure, empirical legal research, criminology, and victimology. Thank you.
Thank you, ma'am. It is a profound honor to welcome our Honorable Vice Chancellor, Dr. G.S. Bajpai, sir, a towering figure in the field of legal education and the criminal justice reform, an eminent scholar, policy influencer, and visionary academician. Sir's contribution has significantly shaped the interface of law, justice, and research in India. We are truly privileged to have you with us, sir. May I now request you to kindly grace us with the inaugural address and set the tone for NYAYARTH 2025.
Very good morning to all present, and it is my privilege to be with you this morning to attend this very important national conference on law, language, and forensic science, being organized by Shri Vaishnav Vidyapeeth Vishwavidyalaya Indore. And my greetings to the director, Professor Prasad, and the convener of this program, Dr. Swati Mishra, and my greetings to all the learned faculty members who are present today, dear students, ladies and gentlemen. This is a very important occasion for me to speak on this theme, which is very judiciously identified as law, language, and forensic science, a synergistic approach to justice. You know, in the beginning, I would say that in a world where the pursuit of justice is ever more complex, we recognize that the intersection of these three pillars which you have chosen for this conference, law, language, and forensic science, is where clarity, fairness, and truth converge. And my objective today is to explore how these distinct disciplines collaborate and reinforce one another, enabling us to administer justice with greater precision, equality, and humanity. The first, let me turn to the foundation of justice, because all the pursuits lead to the core idea of justice. So in that sense, my first take is about the foundation of justice, because at the heart of any legal system is the rule of law, the principle that all individuals and institutions are subject to and accountable to the law. This foundation is actually sustained and operationalized uh, through two very interdependent avenues. One is language, because I'm trying to locate the importance of language in exploring and understanding the legal ideas, legal issues, legal subject matter. So, in the context of language, I say that the primary tool for articulating rights, recording evidences, constructing arguments, and decreeing judgments, language is the medium through which the laws are promulgated, legal rights are defended, legal reasoning is communicated. And secondly, forensic science. Forensic science is the application of scientific method and principles to investigate crimes, and clarify facts. So it serves the crucial function of translating physical and digital evidences into reliable knowledge, knowledge that can shape legal outcomes. So, therefore, individually, each domain plays a vital role together. However, they create a synergy, a multidisciplinary blend in which complexity can be unraveled with rigor and nuance. Now, I further turn to language as a vehicle of legal meaning. So, let me first speak to the foundational role of language. As I've said, law is fundamentally a linguistic construct. I repeat, law is fundamentally a linguistic construct crafted in statutes, treaties, regulations, court opinions, and legal commentary. So each word matters. Every phrasing carries implications, and every sentence structure can alter interpretation. So here the language becomes very, very crucial. Now let us look at the statutory interpretation, because legal drafters labor meticulously to choose words and convey precise meaning. Judges and lawyers interpret those words, sometimes decade later, in circumstances neither foreseen nor articulated. Purposivism and textualism illustrate how language is negotiated. So, language is very crucial. Now, second issue is, which you are all aware, I call it legal rhetoric. Legal rhetoric, see, in courtrooms, language becomes performative because we perform through language in the court of law. It persuades juries, judges, lawyers, even judges. And so you pursue with language. Language is a tool, a very important craft, which is utilized by the functionaries of the legal system. Arguments are crafted, counter arguments dismantled, precedent invoked, and mitigations invoked, all through the language. This is the magic of language. Now, if I take you to access to justice, again, a very foundational aspect of justice, legal language often acts as a gatekeeper. In the context of access to justice, I'm saying the ability to understand complex legal documents can influence whether individual can meaningfully access justice. Plain language, reform, and procedural simplifications are not luxuries. They are essential to equitable justice. So the language in law is not simply a passive medium. It is an active agent shaping outcomes, molding perception, and demanding accountability. So this is the whole perspective that I need to place before you in the context of justice. Now let me come to forensic science and the language of evidence, because forensic science, we see a discipline founded on empiricism, the identification, analysis, and interpretation of evidence using methodologies anchored in science. So, forensic science is a scientific medium where physical evidences, fingerprints, DNA, ballistics, toxicology, trace elements are matters of empirical fact. Yet they must be interpreted in context. So a DNA match is not self-evident proof of guilt. Presence at a crime scene must correlate with intent or action. I'm sure you must have, in the recent past, seen the case of Anokhi Lal, not very far from Indore. The matter was decided initially twice on the basis of DNA evidence, where the death penalty was upheld by the court twice. Third time, Project 39A from NLU Delhi, a spirited lawyer working in that Project 39A, represented the accused Anokhi Lal, and she challenged the protocols of DNA, not the scientificity of DNA, but the protocols of DNA. I mean, the manner in which the sample was taken, preserved, carried out, extended, etc. There were number of loopholes identified, and finally it was established that the sample taken from allegedly taken from Anokhi Lal didn't belong to him. Will you believe the person who was twice convicted for death penalty was set free after 11 years? So here the articulation, the context, the interpretation played a very important role. So on the one hand, you have a scientific evidence, a report. On the other hand, there is a lawyer who is there to interpret the results of that test, can create a wonderful outcome. Anyway, second issue is we know the pattern analysis, digital forensics. All these things have a very important scientific basis. But scientific certainty is seldom infinite, that we have seen in case of DNA also. What forensic science offers is a rigorous, replicable, transparent path to conclusions. Yet, it must, but does not always, speak the same language that courts demand. And in fact, I would say in Anokhi Lal, when the DNA report was presented by the concerned scientist, problem was the judges may not be well aware of all the nitty-gritty of DNA evidence. Therefore, it was allowed, it was accepted. But when they faced a learned lawyer who had the necessary competence to analyze DNA evidence report, she was able to convince the judge, that is the magic of language, that the DNA that was relied in Anokhi Lal cannot be accepted for want of various reasons. And those reasons and reasonings were accepted by the court. You please read this path-breaking, phenomenal, exceptional, and unparalleled story of the sustainability of DNA evidence. Anyway, now I come to the fourth dimension of my talk today. That is the synergy. Ultimately, synergy, which is the focal point of discussion in your conference, synergy of language and science in courtroom practice. So this brings me to the synergy. So the forensic data must be translated into legal language. That is the requirement. And legal trials in turn must account for scientific uncertainty without sacrificing clarity. The role of expert witness, he is someone who bridges the gap. They translate technical results into lay language and convey to the judge and jury that those results signify or do not signify with scientific integrity. That is the role of expert witness. Now, to consider DNA expert again, the laboratory analysis may show a statistical likelihood of identity, because DNA is used for the establishment of identities in most cases. The expert conveys that likelihood using probabilities, expressing the strength of match but also acknowledging the margins of error. In their testimony, language becomes their tool to calibrate precisions without, overstating certainty. Now, if I take you further to highlight the precision of language at the stage of cross examination. So we know that opposing counsel, I mean their defense, often interrogates the expert's language, drilling into words like probable, consistent with, cannot exclude. So the lawyers use these words because every word has a crucial meaning in the eyes of law. So whether the report goes to the probability or whether it is consistent with or cannot exclude. So these words have nuance. So a slip in phrasing can mislead the judges or create certain doubts. Therefore, precision matters and language becomes the arena in which the conclusions of science are contested, not the lab bench. So this happens. Now let us see the situation in a courtroom situation. So if I say after hearing testimony, the judges must reconcile expert statements with legal standards. Now, necessarily the expert may not be speaking as per the requirement of the language of law or with the standards of law. Like standards of law means how the report is going to impact are consistent with the requirement of, say, burden of proof, presumption of innocence, reasonable doubt, how the report actually addresses these fundamental presumptions of criminal law. So judge instruction, suppose instructs cornerstone of that reconciliation, demand clarity. They must convey complex legal and scientific concepts in terms of ordinary person can grasp using everyday language without trivializing the substances. Now, what are the challenges when we talk about intersection? So challenges at intersection. So as powerful as the synergy is, three key challenges stand in our way when we talk about synergy or intersection. The first challenge is translation mismatch. So investigative and scientific language is replete with qualifiers. Qualifiers suggests, corresponds, indicates. We use these words. So whether it suggests or it corresponds, these have a different level of certainty and surety. So legal language craves definitive answers. Legal language requires definitive answers. Guilty or not guilty. So whether can you hold a person guilty when evidence is merely suggestive or correspondence or indicates. So whether it indicates is the standard. Now the task of bridging this gap requires both fields to inoculate language against distortion while ensuring scientific findings are not weakened in translation. Now, second aspect or second challenge is over-reliance and misunderstanding. Judges may accord forensic evidence undue weight at times. Like if DNA report comes in the court, all judges will say fine, 100%. Medical report, 100% agreement. Assuming science is infallible Science is also not infinite. There are, I'm sure forensic scientists must have heard junk sciences. Now, a lot of standards in even sciences are being categorized as junk science. So the phenomena of CSI syndrome is a testament to that risk. Now, conversely, judges or defense counsel may reject valid expert method demanding a level of certainty that science cannot provide. So, third is language barriers for non-specialists. Lawyers and judges often lack, deep scientific training. So expert testimony, therefore, may remain opaque. The opacity undermines justice. The burden falls on education, both legal training in science and scientific literacy in legal professionals, both ways. Now, what are the pathways? We have to find the pathways to synergistic future. How do we overcome these challenges? What are the, levers we can pull to refine synergy? The first is terminology harmonization. So, agreed glossaries jointly developed by legal professionals and scientists and linguists can establish standard definition for critical terms like probable cause, significance, non-conclusive, exclusion, and these glossaries could be very, very useful. Next is training, collaborative education, where legal professionals benefit from training in scientific principles, and similarly, scientists can be benefited from legal procedure and interdisciplinary workshops. All these things can be very, very useful. Next is standards, accreditation, and quality control. Forensic labs and practitioners require accreditation, uh, standard operating procedure, and validation studies. Because stringent standards bolster credibility, we understand. So, uniform adherence to protocols enables language of evidence that is reliable, comparable and defensible. So reports become standardized, terminology becomes consistent, and trust increases. Now, judicial engagement and guidance is the next, aspect that I wish to touch, because judges play a central role as a gatekeeper. So clear standards for admissibility is needed. So, because this requires judges to evaluate the reliability and relevance of expert evidence. Next is community outreach and public education, because society must believe in fairness of the justice system. Without public confidence, even the most sophisticated synergy collapses. Outreach programs, mediation clinic, community workshop are very, very important. So a scientifically literate public is better positioned to trust and hold accountable the justice system. Now, uh, I always feel that the case studies are the best method when we need to look at synergy in action, because the real world illustrations are very important. So if I say, I have mentioned Anokhilal, but misinterpreted statistical evidences is the first case study that we may look at, where a forensic expert phrases a DNA match probability as only 1 in a million people would match. Generally, they say only 1 in a million people would match. The judge hears that and concludes something, but it is the judge's obligation to weigh this probability against the size of the relevant population and possibility of lab error. Generally, courts hardly pay any attention or do not really try very hard to actually examine any prospects of lab error or misaligned translation of statistical language that can distort justice. Now, second situation, if you see the footprint and you know judicial comprehension. So, Defense Counsel called digital forensic analysts to testify on, say, recovered, browser histories. So, complex terms like hex data, metadata, timestamp integrity were glossed without elaboration. These words are used. But judges later ruled that the testimony ended as inadmissible as scientific evidences and case collapsed. So a missed opportunity for calibrated communication. This is the and similarly, there are many such examples which illustrate that accurate science alone is not enough. Language must also consistently and clearly convey the underlying uncertainty, protocol integrity, and evaluative context. Now, in the end, if I place a very broader vision, I'm in the global trends and digital transformation and globalization of evidences because we know that transnational crime demands cross border cooperation, Interpol, mutual legal assistance, and what we call digital service providers. So, harmonizing legal language across jurisdiction becomes vital. Shared forensic standards, ISO, EO protocol, UNODC guidelines, all these help the language worldwide. And we also have now artificial intelligence and algorithmic evidences, which are increasingly being used to identify the suspects, detect patterns, and even predict criminal behavior. So the language used by AI system is opaque, reliant on complex code, hidden layers, and proprietary parameters. Explainable AI movement to open this language to legal scrutiny. If we cannot translate algorithmic outputs into explainable, legally meaningful terms, we threaten due process, basically. And similarly, in the end, ethical dimensions relating to language, truth, and justice are also very, very important because, to my mind, ethics thread through each aspect of the synergy that we are talking. So, legal ethics compel lawyers to challenge the expert testimony that is misleading or unreliable. Scientific ethics demand honest interpretations of accuracy. Linguistic ethics require communicators to avoid jargon, clarify qualifiers, and ensure coherence. So justice demands that complex knowledge be conveyed clearly, truthfully, and respectfully, especially to those whose fate depends on it. And therefore, there is a call for action. To conclude, my call to action is threefold: institutional integration, where we develop interdisciplinary centers of excellence, where we promote dialogues among prosecutors, judges, and other stakeholders in the system. Second is to create standards and accreditation by expanding robust accreditation schemes for forensic labs, encourage standards reporting formats which are scientifically precise and legally accessible. And third is ongoing education and public outreach to continuing education, credits for legal and scientific professionals and interdisciplinary competencies. Invest in public education. And ladies and gentlemen, in a time when justice faces pressures, mass criminalization, mistrust, digital complexity, the synergy of law, language, and forensic science offers a powerful anchor. So, together, they can illuminate the truth, safeguard rights, and uphold dignity of every person who enters our criminal justice system. Because we say justice is not a static destination, it is a dynamic equilibrium requiring constant calibration. So, law alone is too brittle without clarity. Science alone is isolated without legal relevance. Language alone is hollow without evidence. But together, they form the architecture of a system that can rigorously seek truth, treat people and deliver judgments. So it is our shared responsibility, whether we wear judicial robe, lab coats, legal suits, or communication experts, to enforce this synergy, champion rigorous standards, and never lose sight of the humanity at the center of justice. Thank you for your attention and engagements. I look forward to robust discussion ahead in the conference, and I hope you enjoy the rest of the conference. Thank you so much for having me today here.
Thank you, sir. Thank you so much, sir.
Thank you, sir, for your insightful address. Thank you for beautifully analyzing every dimension of our law, language, and justice theme. Thank you for setting the tone of NYAYARTH, which promises to be a meaningful and an impactful two-day conference. With great pride and anticipation, I now declare NYAYARTH National Conference on Law and Forensic Science officially open. Over the next 2 days, we look forward over to the plenary sessions led by experts and concrete sessions showcasing cutting-edge research from scholars across India, interactive dialogues, exploring challenges and innovations. Now, I take privilege to request Dr. Swati Dubey Mishra ma'am, convener and coordinator of NYAYA 2025, whose unwavering support and guidance has been instrumental in the success of this event, to deliver the vote of thanks. Over to you, ma'am.
Thank you, Madam Akanksha. Respected Chief Guest of this occasion, Dr. G.S. Bajpai, Honorable Vice Chancellor, National Law University, Delhi. Dr. Tarak Nath Prasad, Director of Law Institute and convener of the conference. Dr. Ashutosh Bairagi, Professor Law Institute, coordinator of this conference, esteemed speakers, faculty members, scholars, and dear participants. A very warm and heartfelt thank you to each one of you. It is my privilege and honor to deliver vote of thanks on behalf of Sri Vaishnav Institute of Law and Vaishnav Institute of Forensic Science. This inaugural ceremony of NYAYARTH 2025 marks the beginning of an intellectual journey committed to the cause of justice through the collaboration of law, language, and forensic science. First and foremost, we extend our heartfelt gratitude to our chief guest, Dr. G.S. Bajpai, Honorable Vice Chancellor of National Law University, Delhi, for gracing us with his presence. Sir, here I want to say that न चौरहार्यम न च राजहार्यम न भ्रातु भाज्यम न च भारकारी व्यम कृते वर्धत एव नित्यम विद्याधनम सर्वधनम प्रदानम। सर, आपको विद्या का ऐसा वरदान है जिससे कि कानून के क्षेत्र में आपने ऐतिहासिक आयाम गढ़े। Once again, thank you so much, sir. You have been an inspiration to me since my college time. We are truly humbled by your presence. Next, our special thanks to the visionary leader of our university, Dr. Yogesh Chandra Goswami, Honorable Vice Chancellor of SVVV, for his unwavering support and encouraging guidance that have infused great energy into this conference. Thank you to Convener and Director, Law Institute, Dr. Tarak Nath Prasad, for his unwavering support and encouraging guidance, which have brought great movement and direction to this conference. I would also like to sincerely thank to Dr. Ashutosh Bairagi, Professor, Sri Vaishnav Institute of Law, for his thoughtful discussion and support during the preparation of this conference. We are grateful to all the dignitaries who joined virtually and to all participants who have connected from across the length and breadth of India, from the north to south, east to west. Your presence is the true strength of this platform. I would be remiss if I did not express my sincere appreciation to our dedicated conference coordinators, Professor Jagrati Gupta, Akanksha Surana, and Aswati Chandran Nair, whose wholehearted involvement, attention to detail, and behind-the-scene commitment ensured the smooth conduct of every element of NYAYARTH 2025. On behalf of all of us, a heartfelt thank you for being the backbone of this conference. I would also like to express sincere appreciation to the organizing committee, technical support staff, student volunteers, and every unseen hand working tirelessly behind the scenes. I thank you once again for the bottom of my heart. Thank you, sir. Over to Akanksha, ma'am.
Thank you, ma'am. I request every esteemed member of the conference to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Special thank you to our institutional leadership for constantly supporting academic innovation. With this, we conclude the inaugural ceremony, wishing everyone a stimulating and thought-provoking conference ahead. Thank you.
Thank you so much, sir. Vajpayee, sir.
Thank
once
you,
again.
thank you, thank you so
Thank you,
much.
sir.
Thank you so
Thank
much.
you. Sir,
Thank you, everybody. My pleasure.
Thank you, sir.
I now request every participant to kindly join us at 1 o'clock for the plenary session where we'll be assisted by and we'll be guided by all our speakers, chairs and co-chairs. Thank you. You may now leave the meeting.